Let's go back to one of our top stories this evening, where President Cyril Ramaphosa says the age of the newly appointed National Director of Public Prosecutions is not the main priority, but the work that he will undertake to transform the NPA. Mothibi, who is 63 years of age, has some questioning, or rather has some questioning, whether he'll have enough time to get things done. Accountability Now's Paul Hoffman joins us for more reaction. Advocate Hoffman, good to have you on the program this evening. Firstly, how significant is it that President Ramaphosa even went ahead to appoint Advocate Mothibi as NDPP, even though he was not among those 6 candidates that were interviewed and shortlisted by the advisory panel? To put it simply, what precedent does this set for merit-based appointments?
Yes, good evening to you and to your viewers as well. Thank you for the opportunity. The President has an unfettered discretion to appoint the National Director of Public Prosecutions. He's not obliged to appoint a panel to help him choose the National Director of Public Prosecutions. He could actually do what he has done without fear of contradiction, because it is a matter within his sole discretion. And having said that, not even on the long list of 32 candidates was Andy Moshibi's name there. And the final 6, who were all not acceptable to the panel, did not include his name either. He was not prepared to put his name into the hat like everybody else did, and he was not prepared to allow anybody else to nominate him for the position. Well, that at least was Moshibi's position last year, but this year he seems to have changed. Then he's persuaded by the President to accept the appointment at the age of 63, and it is an appointment which by law has to end at the end of the month in which he turns 65. So he's not going to be there long enough to do anything particularly useful unless he moves at the speed of light. There's plenty that needs to be done in the National Prosecuting Authority. A lot of reform is on the table already. The Constitutional Court has said that anti-corruption work should be done by a body which is outside executive control, a specialist body. The NPA is not a specialist body, and it is certainly not outside executive control. So those aspects will have to be addressed if the course correction for the NPA, which has been sought for so long and has not yet been achieved, is to be achieved on Andy Moshibi's watch. Of course, the 65-year age limit on the NDPP can be changed by changing the law, but one doesn't know whether the President intends to do that. He hasn't said so, and one certainly doesn't know whether the intention is to soldier on with the NPA trying to do all of the prosecutorial work that it has tried to do in the past without success, especially in the anti-corruption field, and whether the problems of the NPA can be addressed by Advocate Moshibi, who is indeed an excellent candidate and a person who could do the job well if given the opportunity to do so.
Taking from that Advocate Mothibi is an excellent legal mind. These were words that were echoed earlier on by President Cyril Ramaphosa speaking at a golf day event. Let's look at Mothibi's track record beyond his age. I mean, Mothibi comes from the SIU, an anti-corruption body with investigative powers, but no prosecutorial mandate. What risks or advantages does this background then bring to leading the NPA?
Yes, for the last 10 years, he has been leading the SIU, as you see on your screen right now. And that body is not part of the criminal justice administration at all. Its job is to act in terms of proclamations made by the President giving it a mandate to rake back loot, if you permit me to use three four-letter words in a row. Raking back loot is the work of the SIU, and under his leadership, the SIU has done very well on Advocate Mothibi's watch. It wins awards. It has recovered billions of rands of the loot of state capture, the loot of the PPE corruption, and indeed all sorts of work in relation to recovering money stolen from the government or from state-owned enterprises.
Yeah.
But that is not the job of the leader of the NPA. The work of the NPA is to prosecute crime, and in order to do that successfully, you have to be able to prove your case beyond a reasonable doubt to the satisfaction of the judge or magistrate hearing the case. That is not the case in relation to the work of the SIU, which happens in civil courts, where the onus of proof is only on a balance of probabilities rather than beyond a reasonable doubt to the satisfaction of the judge or magistrate hearing the criminal case. So he's not playing in the same place or same space as he was in while he was with the SIU. That doesn't detract from his competence as a lawyer and from the good work that he has done, for example, in connection with the work of the anti-corruption working group of the G20, which met at Skukuza at the end of last year. He co-chaired that, and he acquitted himself very well during the proceedings.
Yeah. Advocate Hoffman, given the NPA's recent history of political interference as well, leadership turnover and weakened institutional capacity, if you will, do you think this appointment is more likely to strengthen prosecutorial independence, or could it exacerbate perceptions of a politicization of this unit?
Yes, I'm sorry to burst your bubble, but there is no prosecutorial independence in South Africa. The prosecution service is, in terms of the Constitution, under the final responsibility of the Minister of Justice. Its accounting officer is the Director General of Justice. Its policy has to be concurred in by the Minister of Justice, and it operates as a program within the Department of Justice. So it's not a question of strengthening the independence of the prosecution service. It's a question of whether the prosecution service can continue floundering as it has, especially in relation to anti-corruption work, or whether Advocate Mothibi, as a respecter of the rule of law and as a competent advocate, as the President has said, will not tolerate the failure of government to bring the situation on the ground, which requires a body outside executive control to deal with corruption effectively. Whether Mothibi will be given the opportunity to do so in the limited time available to him by law is really a question that we should be asking the President rather than asking Advocate Mothibi, because it is a question of changing the legislative framework. That's not to say that this isn't being attended to. Glynis Breitenbach has 2 private members' bills in the works in Parliament, which envisage the enablement and establishment of a Chapter 9 body to deal with corruption outside executive control. And the National Anti-Corruption Advisory Council has made recommendations, which have not yet been accepted by Cabinet, that an Office of Public Integrity should be created. That is a problematic proposal because the Office of Public Integrity has to take instructions from the President in much the same way as the SIU currently does. The Special Investigation Unit, which is not part of the Criminal Justice Administration, it's located in the presidency, takes instructions from the president to rake back loot, as I said earlier.
Yeah.
That feature of the Office of Public Integrity makes it somewhat less than a proper Chapter 9 institution. Indeed, it would be unconstitutional to create an Office of Public Integrity as a Chapter 9 institution if it has a reporting line to the president and if it takes instructions from the president, because he heads the executive branch of government, and the court has very clearly said that anti-corruption work in South Africa must be conducted by a body outside executive control. So how Advocate Mothibi negotiates that, and I'm sure he can do better than his predecessor has done, because she has done nothing on that front, remains to be seen.
Yeah. Advocate Hoffman, before I let you go, I also want to get a sense from you on the legal challenges that have also come with this appointment. So observers have indicated that there's already a legal challenge underway in the Gauteng High Court to stop the appointment process. On what constitutional or procedural grounds might such a challenge be based, if at all?
Yes, I'm glad you gave me the if at all option, because there is no basis. The legal position is that the appointment is within the discretion of the president, and provided the president does not exercise his discretion in an irrational manner, which certainly isn't the case in relation to Advocate Mothibi's appointment, there is no legal basis for attacking it. And the application that is pending, which seems to be directed against the entire panel process, which has fallen by the wayside anyway because the panel couldn't find anybody suitable, and more particularly against the candidacy of Hermione Cronje, who has not succeeded. So really, the legal challenge that was launched is ill-fated. It's not going to get anywhere.
That's Accountability Now's advocate Paul Hoffman giving us a sense of his views on Advocate Andy Mothibi being appointed the country's new National Director of Public Prosecutions.